everyone for spending your evening here with us. And today we have an amazing guest speaker, Scott Bollinger, real estate lawyer, who's going to be talking about creative financing.
Yeah.
Give Scott a round of applause.
Oh.
We have
Thank you, sir.
pointer here.
Oh, okay. So I'm going to do the arrows here. Great. Thank you very much. Thanks for coming out, guys. I'll try to be I try to be brief, but you'll see. You can be the judge of that. So I thought today. Well, here the introduction. There's that disclaimer too. So right, we're not creating any legal relationship here. I'm just sort of giving you some information from experience and from the books, right, about what we're talking about. So introduction for me, I'm a real estate lawyer. We primarily do real estate transactions. I have a small shop. It's just me and some paralegals and assistants. And we, again, focus on real estate. We do some wills and estates and some corporate stuff, but we would generally just do that with if it's related to the real estate files. And so when I say real estate, it's almost exclusively transactional real estate, contracts, drafting, that sort of thing. But again, mostly just transactional. So when I speak about the topics that we're about to talk about, I have experience in all of them, some more than others, and I have my preferred transactions as well. We can talk about that, but anyway, so that's my. The other thing I should say is real estate lawyer. I've only been a lawyer since 2018. Prior to that, I was a realtor. I was a mortgage. I did have my mortgage broker's license for a while. I ran a small family and friends mortgage investment corporation, and then I also had a real estate brokerage too. So I've been around the real estate game for a while. I know the transactions from all sides, and so it gives me some, unique experience with respect to being a lawyer. And when I went back to law school, which was in my 30s, and it was painful, but I was glad I did after that. And I stuck with what I knew, so because I'm too old to learn anything new. So anyway, so let's move on to the topics tonight. I thought the best thing we could do, because I wasn't sure what kind of a group I'd be talking to, I thought, well, we'll go through, summarize, a bunch of investment structures in residential real estate in Alberta that are, somewhat common, and then we can distinguish. We can summarize them. We can distinguish between them because some of them need distinguishing, and then then hopefully we leave some time for some questions, and we can dig into those even if you wanna ask me questions. So there's the list you saw. Okay, so I won't repeat it, but we talk about vendor take-back financing as one of the options for investment. Okay. This is pretty basic. It's a real estate transaction where the buyer pays only a portion of the funds to the seller, and then the seller takes back financing. And they would do that either in place of the buyer's mortgage or in addition to the buyer's mortgage. So, the buyer pays $100,000 on a $400,000 property and then gets a $300,000 mortgage from the seller, which is registered on title. But the buyer might pay $100,000 to the seller, take a $200,000 mortgage, and then get a $100,000 mortgage back from the seller. I mean, it just depends on how you want what works for all of the parties. This is not common. It's not as common as some of the other structures, I guess I would say, but it works, and there is a place for it. I would say, like for example, where does this? Well, first of all, the seller has to have no mortgage, or they have to have a small enough mortgage that it's going to get paid out from whatever cash is being advanced on closing. So that limits the market there. But then a lot of sellers just want to walk away. They don't want to be involved. They don't. So you're gonna find that it's difficult to find sellers like that. But there is a place and a time. Example. Sylvan Lake area, an older fellow probably wanted more for his property than what he could get on a standard transaction. He found an investor who was willing to maybe giving a premium as long as the seller was to, take back financing. It was good for the buyer because the buyer then turned around and acquired the property, and then short-term rental, which I think worked out okay for them, and then ultimately they refinanced. So that's one example of how the vendor take back would work. Also, builders or developers might be interested in this type of arrangement, where they can acquire a property. A lot of times it's a development property, and that's typically a lot of times, again, from an older seller who may or may not have a mortgage. And if they don't, then it's easy to take back the financing there. And it might give that developer, there's a bunch of scenarios, but the developer might just acquire the property and then be able to sit on it for months and months and months while they did their plans or got their development permit or acquired other properties or whatever while they had control of the property. So that's another example of where you might see vendor take back in this market. Okay, so next one is the assignment of contract, or what we would refer to as wholesaling. Okay, so this is this has grown in popularity in the last few years, and it's definitely become more competitive. But it's an interesting scenario. So you, as an investor or business person, you would find a property, you get it under contract with the seller, and then you could assign that contract, both the rights to the purchase, right, at the certain purchase price, and at the possession date. So that's and then also your obligations. You're assigning all of that to the third-party buyer, and you take a fee for that, which is like I said, happening quite often in this marketplace, and people do very well on it. It's surprising to me how many sellers are willing to sell to off-market and to wholesale type investors who they know are likely going to make a profit on it by assigning the contract, because of various reasons, whether it's because they don't want to move their stuff out, they're hoarders, or maybe they're embarrassed about something else in their lives, or whatever it is, or they just don't want to deal with realtors. There's just all kinds of scenarios, and anyway, there's lots of opportunity there. But things to note, okay, in when you're doing this. So first of all, in Alberta, contracts are assignable unless the contract prohibits it in writing. Okay, so if the contract says no assignments, you can't assign it. But if it doesn't say anything like that, then you're typically able to assign it. But you have risks in this, because even if you don't necessarily have to disclose it to the seller, okay, when you're a buyer, that you're planning to do this. But if you don't, you're going to possibly run into some disappointment or disaffection or all kinds of other problems that may arise, which cause you reputational damage and other issues. So you got to consider that. You also have to know that when you're assigning a contract, if you're not getting the consent of the seller in a formal way, and the consent, by consent I mean a release of liability, then you continue on with your liability. Okay, so you may assign the contract to a third-party buyer, but if that third-party buyer doesn't close, then you, as the initial party under the contract and having privity of contract with the seller, you have responsibility to the seller for damages. Can you get out of that? Yes, a release by the seller, but typically that's not, what's in it for them, nothing. And then the other way that some people try to get out of it is to actually amend the contract name, okay? And if the seller, sometimes they'll put in the contract, the seller agrees to do that, and the seller will do that. But the problem with that is that you now complicate whether you're assigning the contract or simply amending the contract, right? So if you have a purchase contract and you're assigning it and you're trying to gain a fee for that, you confuse whether you're actually entitled to a fee if you just amend the contract, because there's no contract assignment there, it's just an amendment, and if that makes sense. So anyway, we can talk about that if you have any questions. The other thing I would note here is that lots of people do this, and lots of people do it on a volume basis. but it does beg the question about whether you need a real estate license. Because a lot of people who do it don't have a real estate license, and then the Real Estate Act requires you to have a real estate license if you're trading in real estate. The defined trading in real estate is bringing parties together and getting paid for it effectively. So in this case, you can make when you're signing a contract, you can make a good case, at least on a one-off basis, that you don't need a real estate license because you actually have an ownership interest in the property, or at least a purchaser's interest, which would turn into an ownership interest, and you're doing it on your behalf, right? And so you're not a third party. You're actually transferring your interest to somebody else, and you can get paid for it. So that, on a one-off basis or a periodic basis, I think is a safe legal argument to protect you. But if you do this on a more systematic basis, you may want to consider whether you need a real estate license, because that colors the interpretation. Okay. Limited partnerships. I don't do LPs. One of the big reasons is because I got to deal with securities laws if I dabble in LPs, and there's just too much to know, so I always refer it out. But this is a really good way, obviously, of bringing together multiple parties, pooling money, and then securing their investment in the property. It's more complicated. It's a higher setup cost for sure. And there's been lots of successful stories along these lines. There's also been some not so good stories. And sorry?
I just said some epic fails.
Epic fails, thank you. Yes. So that exactly. But it is theoretically, it's a great structure, and it's more complicated, obviously, than the others that we've been talking about. Okay, so joint venture. So since we've been talking about limited partnerships, let's go back to joint venture. Joint venture is a similar concept, but you're going to do that with fewer people, and you're going to do it without having to deal with securities laws, and prospectuses and all that stuff. So it's just a contractual relationship. So it's not governed by any particular piece of legislation. So you can basically write into the contract whatever you want, but the generic or the typical JV will follow very standard guidelines, and so it's going to have specifics about how the venture is managed, how the profits are shared, and how the losses might be shared, your exits, possibilities and strategies, and the purpose, and a whole bunch of other things. The typical JV is something where two parties are supposed to share in both the profits and the losses. Okay, so you'll probably come across some that are just structured as there's kind of a managing partner, a working partner who doesn't put in much or anything in terms of money, and then you've got a money partner. That is debatable. I mean, that works. It works. It's contractual. There's not too much that I would criticize it for. It is just, except to say that theoretically, right? If you were ever to get in a tax debate with CRA about whether it's a joint venture or whether it's just a loan or a limited partnership or something like that, that the more if you're wanting to argue that it's a joint venture, the more that both parties share in both the profits and the losses, the better you are. Okay, better off you are in that argument. Beneficial ownership is acquired through joint venture, so you can register that on title. It's worth noting that there are, again, some investors that would like the sound of a JV because they think, okay, well, I can have one person who, say, qualifies for a mortgage, and they're on title, and then I can be the silent partner, but actually share in the equitable ownership through this JV, and that happens a lot. But you should, again, note there that there are disclosure requirements and you really do, to not get yourself in trouble, you want to be upfront with lenders and whoever else that's participating in this, that there is equitable ownership through the joint venture agreement. And you'll find the lender who's okay with that. You may not every one of them will be, but it's better to be upfront about it rather than not disclosing it and having allegations about mortgage fraud or other things against you. All right. A couple of different lending structures. The caveat loan. This one's another one where I think we've had a bunch of epic fails recently. Mostly because the stories that we hear, they're investors lending on prom notes, which are unsecured. That's the main reason, I think, but not the only reason, but the main reason for a bunch of people losing money. But this is a really good, simple way to just be a lender, do it quickly and to do it cost effectively, and to still, have a registered charge on title to secure your priority. Okay, so the problem with this is that with a caveat in particular as your security is that, one, the caveat can be removed. So there is a way to do that if you're not on top of things. So, for example, people can serve you notice if you don't reply in a certain period of time, commence an action or whatever. Then they can remove your caveat. And secondly, the caveat that's securing the prom note, which goes on title to a property, does not give you the robust remedies of foreclosure, right? So what does that mean? That just means basically that, you have something on title. The borrower is going to have to deal with you at some point if they refinance or sell or get into other kinds of trouble. But until then, they don't really have to deal with you, right? You can't force their hand, right? So as opposed to a foreclosure or a mortgage, which allows for foreclosure, which you can force that remedy. So, and then better form of lending is private lending, and that's my preferred way of investing at this stage in my life because it's less active. It's not it's not so active as opposed to those other ways, and obviously it provides really good security as long as I'm lending to good borrowers and the properties have the right value, and I'm not going too far into loan to value ratio risk. So how does this happen? I mean, you get these opportunities through your networks, through brokers, lawyers, right? We see lots of things, lots of opportunities come up through my office for bridge loans where people are maybe a little bit too confident in their ability to purchase without selling, and then they haven't sold in time and they need bridge funds to purchase or that sort of thing. So that happens. And the other thing about mortgages is that, and I guess I could have mentioned that in LPs as well, but registered funds can be accessed. So, if you have RSPs you can put them in self-directed trust companies like Olympia Trust, TFSA, those can be accessed, both yours and whoever else's, in order to loan money to borrowers and be registered on title. So that. Now, let's talk about agreement for sale. This one is going to be, I want to contrast it with rent to own, because a lot of people, when they phone my office, they say, I want to do a rent to own or a option and lease, or usually it's rent to own. I say, okay, are you sure that's what you're thinking about, right? Is it a rent to own or is it an agreement for sale? And so we go through the tenets of each to figure out what they're actually talking about. And a lot of times it is an agreement for sale that they're talking about. So agreement for sale is a purchase, okay, with seller financing, kind of like a vendor take back, but it happens when the mortgage remains on title. The current seller has a mortgage, they maintain it in place, and then the seller also remains on title. So, but what happens is, that's really the difference between that and the vendor take back. Otherwise, ownership transfers, okay? Ownership transfers through an agreement, the purchase contract, which completes in a short period of time. So you would enter into a purchase contract, and then you would set a completion date of April 1. Okay, and so things would be adjusted like taxes and condo fees or whatever, and then you would take possession as the buyer. And at that point, you would at least transfer at least part, if not all, equitable ownership, right? So seller's name remains on title, mortgage remains in place, but you, as the buyer, obtain equitable ownership, and so that means that you can, from that point, take possession of the property and basically operate the property as though you were the owner, right? But in the meantime, you can do that so long as you maintain your obligations under the agreement for sale, which is effectively a financing instrument. So you've agreed to pay the seller a portion of the sale price. The seller will take back financing, which will typically mirror the financing that they have in place. Okay, and and so it would mirror that financing. It could also be additional financing, just depends on how you want to structure it. And then the agreement for sale would set out the terms of that financing arrangement, and it would go for a year or two or something like that. You would make payments, and then over time, after when you get to a maturity date, then you would close, and the seller's name would come off title, and you would go on title. But in the meantime, you can, as a buyer, build equity. You can secure your position on title much better than most, well, I should say at least than a purchaser's interest or a rent-to-own or an option, because your beneficial owner caveat will effectively stop any other creditors, right, from coming after that equity. And so you can protect your equity that way. Doesn't necessarily mean that you don't have to fight about it a little bit, but under the law, you would be successful as long as you've got your caveat in place and you can show that you've been making payments and fulfilling your obligations under the contract. Then say you find out that the seller has a CRA writ that gets placed on title a year after you take possession, right? So that comes in behind and they want their money. Typically, or say RBC, another writ or something like that, well, typically you just have to address the issue with the creditor. The creditor says, oh, all right, this guy only has, like the seller, if there's no equity left because they've already acquired it from you, then you'll be able to get them to take that writ off title. What else?
I didn't quite understand that.
Okay.
So there's a writ.
Yeah. So okay, you will enter into a purchase contract and close on that purchase contract with a financing schedule. Once you've closed on it, so let's say April 1, you've closed on it, you give the seller $50,000, but the rest of the purchase price, $250,000, is financed.
Yep, got that.
And that happens to mirror their mortgage on title. Okay, so whatever it is, an RBC mortgage or something like that. And then so you're going along fine, and the market's so now you've paid $300,000, you've paid the seller's equity, so you owe them nothing except to get rid of the mortgage eventually. Okay, so to pay it down and then pay it off at the maturity date. From April 1, 2026 to April 2027, the property value goes up to $400,000. And in April 2027, a new writ is registered on your title behind your caveat, okay? And that's from the CRA because it says that, and the reason for that is because the seller's name is still on title, okay? So from their perspective, it's like, well, he owes us taxes, we got a writ, we're gonna put it on whatever he owns, and he owns this property, okay? So you would be able to effectively argue with the CRA to remove that, because you would show them all the documentation that you have, which is that you had equitable ownership from a year ago at this price, and therefore any equity in the property that's left over after above $300,000 is now you're entitled to it, not the seller.
And you're discussing it as if you had registered the agreement on sale, like on title.
You must have registered something on title as of the closing date in order to have that priority. Because if you don't have anything, then they'll get in before you, right, in priority, and then you're hooped. Now, does that solve your problem completely? No, because you actually have to argue with that with the CRA or RBC's lawyer or whoever it is, and it could take time and money to do so. I think you'll be successful if that's the case. We have been successful in those cases, but it's a good point, because when you're entering into these transactions, it shows you what kind of risk you're taking, right? There is a risk that the seller is in a bad way, so you need to know their financial situation and hope that the ideal seller is not going to be so bad depraved that that there's going to have 16 creditors coming after him after the transaction closes, and you keep having to explain yourself and argue with them and do those things. But I mean, that's your prerogative. So.
I get what you're saying.
Okay.
So it's only a problem, like CRA would register the writ to try and get the equity out of the property if they were behind on financing or on payment taxing.
Yeah.
Got it.
Right. So the seller has a tax debt. CRA is going to come after whatever they think the seller owns, but you would be protected against that. So if we go, in contrast, would you be in the same scenario? Would you be protected if you're a buyer under a lease and an option? No. No. I mean, you would still have. Okay, so you would still have an option to purchase at the price that $300,000, right? But you haven't actually purchased it. So the problem is, the seller you go along, you're leasing the property for a while, and you say, I'm going to buy this property later at next year at this time for $300,000. If there's a writ registered on that title and it prevents the seller from selling it to you because they cannot clear the title in order to give you the property at $300,000, then the contract is effectively frustrated. It's not frustrated because the seller is liable to you, but in the end, do you get anything out of it? Probably not. I don't. So the difference between agreement for sale and an RTO, right, is rent to own or lease and option. The option. So in this case, you've got a lease contract and an option agreement, but the option that you enter into gives you an option to purchase at a certain price within a certain period of time, and it's a legal binding contract, and you would register that on Title II. But it doesn't give you ownership of the property; it just gives you a purchaser's interest, right? So now your relationship is governed up into that, until you actually exercise the option under the lease contract. So what's the difference really? Well, there's lots. From the buyer's perspective, it's huge. It's a huge difference. There's way less control and fewer legal rights, right? So when you're looking at it from an investment perspective, what's the buyer going to want to do? They're going to want to do AFS, right? Typically, if you're an investor, what's the seller going to want to do? Between those two, probably a rent to own. And there's lots of successful rent to own operations where you have an investor who buys the house, right, and then turns around and sells it by way of lease and option to somebody who wants to buy from them. Typically, the buyers in that scenario they're not investors themselves. They're people who can't afford to buy a house conventionally, maybe can't qualify or whatever. So they're willing to pay a little extra, give them extra time, and work their way through so that they can actually purchase a house. But anyway, that's the distinction. And yeah, I think you'd think about it that I guess we'll maybe, what else? Well, yeah, we can look at these. So differences, right? So what are the pros of AFS? Well, you build equity. You take advantage of, so if as an AFS buyer, you can get into a property without qualifying for a new mortgage yourself, possibly taking advantage of the current existing low rates, right? That was pretty relevant in the last few years. I don't know if it will be going forward, but when people had 1.98% and they still had 3 years left on their mortgage, like, did you want to go out and get a new mortgage to buy that property, or could you just effectively assume their financing? So default. So if you're a buyer under an AFS, you would You would have the risk of foreclosure if you defaulted, right? So if you don't make your payments, or if you don't follow the other fundamental, requirements of the contract, maybe keeping the property in good shape, for example, or not abandoning the property. It's basic. So you got to think about an AFS as really putting the buyer in the position of the borrower and under a mortgage transaction, and the seller as in the position of the lender. So what are the remedies if things go wrong? For the seller, it's foreclosure, right? And for the buyer, that's could be good and bad. Bad because of foreclosure, but good because in a foreclosure action, your equity, if you're legally entitled to it, right? So if you've built up equity over time, you've been working at, you bought a property, it's 2 years have gone by, you've been making the payments for 2 years, and then you go into default, you are going to be entitled to any equity gain under that foreclosure action. So you still only owe the seller what you agreed to pay them, 2 years ago, but you have to make sure you pay them, and so the foreclosure action will but then you would be entitled to any equity that remains after, say, a court-ordered sale or something like that. Okay. One note on that is if you are protected like that, so that it's the equity of redemption, I think is what it's called, as an individual buyer. Okay, so but as a corporate buyer, if you're a corporate buyer under the AFS structure, you and the seller can negotiate out of that protection. So in other words, you could insert a clause. The seller could, insist on a clause that says, if you miss 2 payments and you don't, or 1 payment and I give you a notice and 10 days later you're still in default, that's it. The property reverts back to me and you forfeit everything you've got, basically, right? So whereas as an individual, you could write that into a contract, but you would still be protected under the legislation to say you can't contract out of your equity of redemption, okay? So that's something to think about when you're investing corporately. Really, it just depends on what you put in the contract, right? But that's a possibility. Okay, so a couple of cons for the AFS. There's dual closings involved if you do it properly. So like I said, you're going to enter into a purchase contract, and then you're going to complete on that purchase contract, take possession in the near term, and then ride out, the next year or 2, whatever the term is of the financing arrangement that you've negotiated, and you will then get a maturity date. So there's the first closing, which is going to cost you, and then because you got to put together all the documents and actually close, and then there's the second closing, which is the maturity date, which is where you buy out their mortgage or pay out their mortgage and any balance owing, and then you transfer the title into your name. Okay. RTO. Again, so I would look at it from the seller point of view. What are the pros here? Rent to own. Well, you have full control, right? You maintain full control. You remain on title. You also have a leasing, a landlord-tenant relationship. It's not this buyer. Lender borrower relationship. It's a landlord tenant relationship, so it gives you more control. And faster eviction. So if you get, if your tenant goes into default either on the option or on the lease, then it's not easy, but it's easier than under an AFS to get that person out and keep their money. And drafting. I guess part of that, so it would be less formal in terms of the closing. So it would be just contractual. You could draft the contracts yourself, or you have a lawyer do it. People sign, right? You transfer money, you give possession, and that's it. So it's not quite the same as an AFS. So risks. If you're a buyer on the AFS, again, you could go into foreclosure. Financial exposure. So again, over time, if the property goes down in value, well, you still have an obligation to pay what you agreed to pay. And there's no, the difference is obligation under an AFS as a buyer versus option. Okay, so as a buyer under the RTO. But again, more control, more rights, more remedies under the AFS, but they come with a cost. Note on, so if under an AFS as a buyer, a note on exit strategy. So it's a really good, it's a great structure, and people get excited about it, and they dive headlong into it, and they find out 2 years later that they can't get RBC or Scotiabank to refinance them to pay out the mortgage, right? To actually close and pay out the maturity or the balance owing on maturity. And so they often have, and it's because it's just more complicated. Banks aren't going to generally understand this process. They prefer to see, they're looking at it, it's like the title's not in your name. How is this working? Anyway, so a lot of times what happens is you got to find private money to actually purchase to buy out the AFS, and then you would once your name is on title, then you could refinance with a conventional bank. Yeah.
Okay, that you just answered.
Okay. Yeah.
At the end of the sentence.
Yeah. So that's how it typically goes. Although I have seen some borrowers have convinced Scotiabank for example. It just took a lot longer than it should have. They thought the maturity date was August 1 and it was November something before we were actually closing. So they had to do that dance with the seller. But it's possible that the banks will cooperate. You just shouldn't count on it. You should always have a plan B. I think, what was the other? Due on sale clause, AFS risk. Okay, so that one I talk about all the time. That's the standard one. So when you're entering into this contract, you're effectively assuming the mortgage on title, but that lender has stipulated in their contract with the borrower that there's no assumption and without consent, and they never give consent. So in other words, that's not permitted. Okay, so that's why we structure it so that you'll have so you have the buyer in contract with the seller who has a mortgage, and then we call that the underlying mortgage, and the seller financing, which is granted back to the buyer, mirrors that financing, but it's not the actual assumption of the mortgage. So it gets a bit complicated legally, but that's still not going to get you. If the lender, that's all to say that if the lender discovers this and decides they don't like it, then they have the option to call the mortgage at that point. So that underlying mortgage, which you have been relying on, you think you got 2 years left at 1.9%, and you're going to make those low payments, and it's going to be great. And then 6 months later, you find out, no, RFA has decided to call the mortgage, or whoever it is. Then you need to have a plan B, because at that point, if they go, they force the seller into foreclosure, it's going to be costly for you and for them. So, and you still have an obligation to pay to buy the property, right? So you're going to be stuck in the middle of it. So you want to have a plan B, whether it's private financing or whatever, to get them refinanced. Yes, sir.
Capital gains tax on the date of AFS.
Yeah.
Is capital gains due or on when you take out from the mortgage? When does capital gains, assuming there's an increase in value, both to the AFS
Yeah.
and the end?
Yeah. So your argument is that, right? So if it's $300,000 today, and the seller bought it for $200,000, right? But you're buying it for $3. Yeah, and then it goes up to $4. Like your gain is from 3 to 4, right? So that's your capital gain. The seller's tax event is between whatever he bought it for and $300,000, right? Now the other question is exactly the timing of that. That's debatable, and I would just refer you to a tax expert on that one. Like, I think you can make an argument on either side to say, yeah, I'll just pay the taxes now. I think the CRA prefers that, obviously, but you could also argue that you're not getting paid out the full amount, right, until 2 years down the road, and therefore you haven't received that profit, and so you don't pay on the profit. You could claim that way, but I can't guarantee that they'll agree with you, the CRA, right? It's kind of like getting like a vendor take-back loan. The same debate happens, right? It's like, did you get paid the full amount and so ownership transferred, and so there's a deemed disposition, right? But your argument is, but I didn't receive the full amount of the purchase price, and I've agreed to finance this much over time, so I don't want to pay the taxes until I actually get paid out the mortgage. But I can't say that will be successful, but it's debatable. Okay, yeah. Well, have I beaten the dead horse enough? Do you want to? Anybody have questions or?
Actually, I do have a question.
Yes.
How
have you actually seen a lender call a mortgage because they found out about something like this, any transaction like this?
Never. Never.
I give the same warning all
Yeah,
the time.
yeah.
And they keep it with. I've also never heard it happen.
It never happened. And I don't, people have probably heard the name Barry McGuire. So I've chatted with him a lot. He's the same way. He operated in Alberta as a real estate lawyer doing this for 40 or plus years and never saw it once. Okay. But it's still theoretically possible. And the time I say that it's not a risk, then it's going to happen. So I'm going to say, okay. Yeah. Any other questions? Yes, sir.
Better take back.
Yeah.
Same thing, question on capital gains tax. Is cap gains on VTB, on the possession of the VTB?
Yeah.
Or, so let's say it's a 3-year term.
Yeah.
Can you span out the cap gains?
Yeah, I think you can make that case, but I don't know for sure whether the CRA will, appeal that way of filing your taxes or whether they'll challenge it. I don't know. If it were me, I would claim it that way, right? Because I think I have a valid argument, but yeah. Yes, sir.
I think you answered, but so if I do an AFS with someone,
Yeah.
and then I want to do an RTO with someone else,
Yes.
that's doable. It's
Yes.
Yeah. Theoretically, it is. That's a risk, though, right? So, and I see that quite a bit. So, I mean, I would just say, make sure from the buyer's perspective that you are never going to go into default, because now, if you do, right, you're caught in between. You've got two legal obligations: one to the third-party buyer that you've sold that to, or sold the option to, or whatever you've done, right, which is now in jeopardy because you're now in default with the seller. So, I mean, it's doable. It gets quite complicated, and I see a lot of them that don't go so well. So I would be very cautious about it. But theoretically, that's a possibility. Yeah. Anybody else?
So on an AFS, it's harder to get a finance when you're completing the AFS.
Yeah.
Years down the road.
Yeah.
A bank might not. Is you presenting an AFS?
Yes.
Right? It's not a purchase.
That's right.
Yeah.
That's right. You're going to have, so the AFS is going to be the purchase contract, but that's as actually a schedule to the agreement for sale, right? So you start with the purchase contract. That's how you get it under contract and obtain, everybody's binding promises. And then once you've waived your conditions on that purchase contract, because that purchase contract, by the way, has a schedule that says, well, here's how it's going to go. I'm going to give you $10,000. I'm going to take financing back for $270 and payments of this much, and you're going to give me a power of attorney, and you're going to give me a transfer of land that'll be held in trust. All of that will be in a purchase contract or a Schedule 2. Okay, and then you give that, once you've waived your condition, you give that to the lawyer. The lawyer then basically takes the purchase contract, transforms it into the financing agreement, which is the AFS, right? It's like, okay, well, here's the deal now that you've agreed to, and that's basically the financing of all of this stuff. So here's what you're going to do. You're going to make all these payments, and if you don't, that's the 10 pages that are the foreclosure remedies. Basically, this is what happens, and then then you close, right? And then that agreement, right, is the one that's been executed and between the parties, and that's the one you take to the bank, and the bank looks at it and says, well, that's 20 pages plus the schedule. I don't get it. Okay, so that's the risk, and so if you have a good broker, maybe he can get that through, because he can explain it well enough to the lender or the underwriter or whatever. But I don't see it very often. It's usually, especially because people leave it too late, and you need months and months and months probably in this case, and they leave it till 2 weeks, and then it's like it's not happening. You got to do private lending, and then yeah. Okay. Yes.
And how is this different from just assuming the mortgage? And is that an option here?
Technically, you can assume a mortgage, but the problem is the bank won't let you, right? I mean, I shouldn't say that. So what the bank does in this case is they make you requalify. And so, and then they have their discretion. It's like, look, I've got a new buyer. He wants to assume this mortgage at 1.9, and I could just give him a mortgage at 4%. No, I don't think I'm going to give him this one. So this is how it goes, right? Yeah. So technically it's possible, and it used to happen all the time back in the 80s, apparently, or something, but it just doesn't anymore. Yeah.
I've got a question.
Yeah.
So in the case of like a joint venture agreement where one partner can qualify, she's qualifying for the property, but they don't have the capital.
Yeah.
The other partner brings all the money.
Yes.
But they can't qualify.
Yeah.
In fact, they might drag the application down.
Yeah.
What's the best way to structure that? Because obviously the bank's not going to be like, oh, I just
Yeah.
borrowed money from the partner.
Yeah, I don't know if that's a good answer, but it's really like you have to disclose, like you're required to disclose. I mean, people proceed without disclosing, and they get it done, and they live happily ever after. But if you're asking me, I mean, it's your requirement is to disclose to the lender, because the lender wants to know anything material about that transaction, including ownership, interest, and equitable ownership is as important as anything, more important even than who's on the title. So if you're not disclosing that to the lender, then mortgage fraud is the word for it. Yeah. Okay.
Can there be a scenario where you are both the seller and the buyer, so you have interest in a corporation that you control?
Yeah.
And you wanted to transfer the properties to that corporation. So
Yeah.
is there a way to do an AFS where you both the seller and technically
Yes. Yeah, you can do that. I'm not sure off the top of my head exactly what the benefit would be, but I mean, if you come up with one, then it's technically possible for sure. Yeah, Natasha.
If you have a joint venture and you have more than 50% equitable ownership,
Yeah.
but the other person is on title and you are not, can you still force the sale? Because I think whoever's on title has to sign the documents. But if you have more equitable ownership, can you sign the documents to the sale?
The JV is a contractual arrangement, so you would have to first go to the contract that you signed, right? And if it's a 27-page thing, that it probably has something in there, right, that will deal with that question, right, and give you the answer. If it's a 3-page document, right, that then it probably is silent on that question. So then you've got to make a case through litigation, likely. There's no automatic mechanism where because again, there's no governing legislation that says if this, then that, or whatever. So now you've got to make a case and likely litigate if they don't agree with you, put it through in front of a judge. And in the end, yes, if you have a controlling interest, you will probably end up with the control. But you can't enforce that control without a judge's order, right? Because it's a contract. So if nobody wants to cooperate, then the only guy left to force that is the judge. Yeah.
What do you find are given that you do a lot of these types of structures, what are your favorite kind? Like, what do you find the ones that are more successful where at the end of the day you have two happy people, or is there one, or is it more dependent on the people? Obviously, it's at least partially.
Yeah, it's dependent, but I actually like agreement for sale. I really do. There's a certain market that it works better in. There's obviously there's a lot of cautions that to be gone along with that, because, for example, it's more complicated. So the seller needs to understand what they're doing, right? And that's difficult. But if you're willing to take the time to educate the seller, or maybe they've been to some course as well, and that's so they know more about it. Now, then the other step is that you also have to have the sellers, because there's two different lawyers involved. You can't have one lawyer, and it's just too complicated. There's too much conflict or potential conflict. So 2 lawyers. The seller's lawyer has to know what they're doing, and they have to be familiar with the AFS. Otherwise, you're going to bang your head against the wall as well and spend a lot more money than you should. So there's a whole bunch of factors that have to go into place. But if you can put them in place, it really does end up working really well. Yeah, I've seen a lot of successful AFSs. So
And which guy do you find are the least successful?
Ha.
In terms of ones that come up common enough, but that you see not work out so well.
Joint ventures can be kind of complicated and tricky, and I think partly that's because of the low bar in how you get into them, right? So over which you have to get to enter them. It's just like, hey, you want to do this together? Let's do it together. And do we need to put anything in writing? I guess let's put something in writing. And so we do on a napkin or something like that. And then that's the result. 2 years down the road is, well, now we're fighting and we don't have an exit strategy. So I think joint ventures I see most often where people are coming to me and say, well, what do I do now? And I say, well, I don't litigate, so I got a good name for you. But that's probably the one that's, the caveat loans, be very careful with caveat loans. Make sure they have some form of security. In other words, a charging clause, right? So that you are entitled to register your loan or your interest on title to real estate. And if you don't do that, then I hope you trust the guy that you're giving the money to, because the piece of paper, I mean, yes, you have, if you don't get paid back, you have a legal entitlement to sue that person. But good luck, right? Good luck. You have to sue, you have to get a judgment, and then you have to recover, right? And the recovery is probably the least, the hardest part, right? With people who didn't pay you in the first place. Okay?
Do you mean like a promissory note?
Yeah, a prom note. That's a prom note that's not secured, right?
Yeah.
So at least if the prom note has a charging clause, you can register it against hopefully some property that has equity, and then you can at least wait out their situation until they sell or they get foreclosed on or whatever, and then you're gonna be on title, so they have to address your claim, right? But if you don't have a charging clause, like I said, you sue, you get a judgment, and you got to go through that whole process, which takes months and months and months, maybe years. And then once you get a judgment, now you can put a writ on somebody's title on their personal property and on their real estate. But by that time, they're probably long gone, or the other creditors have gotten to them. Okay.
If you're going through a property that's registerable on title, why not just do mortgage? Like, is there?
Yeah, good question. It's a little more expensive. Yeah, I agree. I completely agree. And I wouldn't ever do it without a mortgage, right? But that's my business. But it's more expensive. Not much. Like we're talking hundreds of dollars in a hundreds of thousands of dollars transaction, typically. So it's more expensive because there's more documents involved. But I say more inconvenient because like a prom note can be signed electronically, right? And then a caveat registered based on that electron, whereas a mortgage has to be signed in person and registered at the land titles office there. But that's effectively it. It's the cost and the convenience, and you'd be amazed at how many people are just like, I don't want to do that. So yeah. Yes, sir.
So on a JV partnership, right? For the partner that is not on title.
Yeah.
If they want to register something on title, what would be the best process to do that?
Yeah.
Make sure that they have some protection.
Yeah, it's pretty easy. So the JV is typically going to have a charging clause as well, just noting that the either partner, but the partner in particular that's not on title, has the ability to register a charge. And then you would just register a caveat, and you'd probably do it through a lawyer. But I don't know if land titles is open to the public anymore, but usually through the lawyer, and it would just be a caveat, right, on title pursuant to the joint venture. Okay, to the joint venture, and that's all it is securing your interest, giving notice to everybody that's looking at the title that there's somebody has an interest and they're in this priority. And it's, how much does that cost once you have a JV agreement? A couple $100 to file. Yeah.
After a follow-on, but
Yeah.
the moment you make that change to the land title, it might flag the lender, right? And if the lender has wording in their mortgage saying that there's no one else who would have beneficial interest.
Yeah. That's correct.
You might have to requalify.
That's correct. That's why it's always good to have disclosed everything to the lender in the first place. But but you're right.
Sorry, is there a mechanism now in Alberta that flags lenders?
No.
Yeah.
But if
If
they renew the mortgage, or if you do a mortgage renewal, I mean, will be the title or whatever, right? Somehow they get notified, then I guess.
They don't. Alberta, we're a little behind in that, but we don't. Again, you should disclose everything.
Yeah.
You don't want to be in a position where you're blackballed from a bank forever.
Yeah.
But no,
There's that potential.
Yeah. it becomes public knowledge. So there's yes, right. Right, but there's no flagging mechanism for lenders, and that's one of the I don't know if that's, does that happen in other provinces too? Yeah.
We just have an antiquated system of
Yeah. So the Land Titles is working on what they call a modernization, program or whatever. So I wonder if that's
people
coming.
working on it, the people that will be out of a job once it's complete.
True. It's going to be a while. It'll be a while. Yeah. But yeah.
Okay.
All right. Yes, sir. Yeah.
Is there a way that someone could own a property through a corporation?
Yeah.
But have the mortgage under their personal name?
Yes, we've done it, but that was years ago.
Yeah. So in almost all cases, the lender is going to insist that the borrower is on the mortgage is the same name on the title. Does it happen where a borrower owns the property, gets the mortgage, and then transfers the title to an associated party or even a third party? Yes. And doesn't notify the lender? Then yeah. And then that's typically where you'll see the lender, the borrower is not matching because the lender didn't get notified, right? As long as the payments keep getting made, they're probably going to keep going, right? But
if you're referring to the in trust, though, like if from a tax perspective, if you're qualified personally, and you do qualify personally, and you put your name personally, you can have a trust letter done from a tax perspective saying that you're personally holding a property for your corporation, so that you can qualify. It doesn't let you off the hook in any way, shape, or form personally, but from a tax perspective, that works for Revenue Canada to be able to write off.
Good point, Lane. So that's a bare trust agreement. Okay,
Yeah.
It's a bare trust agreement. So we see that a lot, right? Where the individual investors, typically they'll buy the house in their own name to start with, and then they want to transfer it to the corporation, right? So for tax purposes or whatever, rather than transferring the title, right? Actually going through and the purchase contract and a transfer at Land Titles, which could be thousands of dollars or whatever, they will just enter into a bare trust agreement, which declares that, right, all of the beneficial ownership is owned entirely by the corporation, and either was transferred, for a certain value, or just retroactively the corporation always owned the property, and then once you have that in place, you can also register a trust declaration on title if you want, but generally not needed as long as you have that documentation. That's all for the purposes of CRA, right? Nobody else really cares about it. The bank is happy because the borrower and the guy on title and the guy on the mortgage is the same.
Because the purpose of having it under the corporation is to exempt people.
Yeah, you're not escaping liability. You're not escaping liability.
Okay, so that's not.
Yes, you're not escaping any liability there. It's just tax consequences or purposes there. Yeah.
I'm sure you can provide clarity in Alberta. If you buy a property conventionally, which if we're talking about rental properties, it's non-recourse that they can't actually come after you personally for any assets. But if you do purchase it in a corp name, then you do become liable with personal guarantees typically.
That's correct. Yeah, that's correct. That's
kind of the opposite of what you've read in every book ever.
Yeah.
In Alberta.
So in Alberta, and I think it's one of the only provinces, it may be the only provinces that has non-recourse loans. Okay, so non-recourse is 20% down, right? Conventional mortgage. In other words, the bank has no recourse except for the property. Okay, it's not a personal guarantee in any way, shape, or form. But as Lane said, if you're gonna buy that same property with a corporation and you wanted to get a loan from the bank will say, yeah, I'll give you the corp the loan, but I want a personal guarantee from the actual principal or the shareholder or the director or whoever it is. And as soon as you give that personal guarantee, well, you're on the hook for the full amount to the bank, no matter what. Yeah. Yes. Yeah.
That's a great answer. Thanks for that from both of you guys. To your point, sir, for in Canada, rental property, if you own rental property, it's considered passive income, so the tax rate is actually higher in the corporation. And it also doesn't make sense from a tax perspective, usually. Unless you can claim that it's an active business, but that takes 5 full-time employees and a lot of extra things. So just personally rolling it into a corporation for tax purposes doesn't It doesn't actually make sense.
The transferring the title, did you have to notify the bank?
You are supposed to under the mortgage, yes. Yeah, because you've disposed of your interest or any portion of your interest, and if you do that, then the bank wants to know about it. Yeah.
'Cause if you own the corporation,
Yeah.
it's still
Yes.
the owner, so what-
Yeah, well, the bank wants to assess that for themselves. Rather than letting you be the judge. Yeah.
Saying like,
Yeah.
Or you say like in the
Yeah.
contract, typically they will have a clause saying
Yes.
that?
Yeah, the mortgage, standard mortgage terms will have that clause that says if you dispose of, change your ownership interest at all, yeah, then,
I mean,
Yeah.
one of the simple reasons to think around that is, from the bank's perspective, if you're suddenly running a business, that probably means that your entire financial situation is changed.
Yeah.
Right?
there's a
Whether or
million
not
scenarios,
that's
yeah.
the case doesn't matter.
Yeah.
But at the very least, that means that they've got costs to reevaluate you as
Mhm.
as a potential lender, right?
Yeah, and the risk you take as the borrower in doing those things is that the bank just does not like whatever you did, and whether you had a good reason for it or not, whether it's justifiable. If they don't like it, they call the mortgage. That's it. You're done. Right? You got to pay up. So, yeah, and you might get blacklisted from that bank, I suppose, for going forward. So, anyway, these risks are not high in a lot of cases, but they're might not be the end of the world for you. You just have to assess them and proceed cautiously. Yeah. All good?
All right, yeah. So Scott, you're gonna be sticking around for a bit?
Yeah, you bet.
Yeah, so yeah, Scott's gonna stick around, and if you guys have any specific questions, otherwise give me a call.
Thank you.